Hello, everyone. I'm Richard Fink, a lawyer who specializes in workers' compensation law in Ontario. Today's our Legal Side WSIB podcast with Richard and Paul.
Hello,
Paul?
everyone. Oh, sorry, Richard. Cut you off there.
Paul?
Apologies. Hello, everyone. My name is Paul Taylor. I'm a paralegal with specialization in workers' compensation and human rights law. If you want to reach out to either one of us or be part of our podcast, you can contact us through the links below. This week's topic is actually a quite interesting one where we'll be talking with Mr. Sharma, who does a lot of representation before what's called as the License Appeals Tribunal for matters involving statutory accident benefits. Very quickly, prior to the creation of this, individuals that were involved in a car accident and had a dispute with their insurance company would do what we normally do, go to court and sue them. Then in, I believe it was 2006 or 7, Mr. Sharma can correct me if I'm wrong, Mr. David Marshall, who was the former president of the WSIB of all places, was empowered by the government at the time, the Liberal government, to create this statutory body and law. And now we have this program, which we're going to talk about the similarities to it and workers' compensation and the workers' compensation system.
Yes, so Mr. Sharma is a litigation lawyer himself. So, Mr. Sharma, maybe you could tell us some of the issues you're having and what is the LAT?
Thank you. And thank you, Richard and Paul, for having me today. As you guys have both stated, I'm a personal injury lawyer in Ontario. Been practicing for a little over a decade now. As far as the accident benefits are concerned and one's ability to have, what we call income replacement benefits or IRB under the statutory accident benefits schedule, there are many issues we face both as consumers as well as lawyers when we're before the License Appeal Tribunal. And the only reason you would be before the License Appeal Tribunal, first and foremost, is if your income replacement benefit was denied by the insurance company.
So, this is following a car accident.
That's correct. Whether you're at fault or not at fault for a car accident in Ontario, you are entitled to make a claim for accident benefits. And one of the benefits available to you are the income replacement benefits or wage replacement. And typically, you're only before the appeal tribunal itself if you are denied the benefit for a medical reason, for example. The insurance company may send you to their doctors. It could be multiple doctors. And their doctors are of the opinion that you're able to work either your occupation or any occupation. And whether it's your occupation or any occupation is dependent upon whether you are beyond the 104-week mark from the date of the accident. If you are denied the benefit after 104 weeks, it's because the insurer believes that you're able to return to some occupation versus not being able to work any occupation. As far as the issues we face at the License Appeal Tribunal, there's a variety of them. One of the most common issues is, how long it takes to actually get to the hearing itself. It could take up to 8 months sometimes, in other cases, 6 months. And as we know, individuals cannot survive without an income. People have rent or mortgages to pay. So timing is one issue. Another issue our clients face is that even if you win this appeal and the adjudicator rules in your favor that yes, you're unable to either work your occupation or any occupation based upon your age, education, and experience, you cannot recover legal costs. You cannot recover disbursements or the money that you are spending to advance your claim. So if you have to call an expert and pay your family doctor to show up to this hearing, or you have to pay a litigation expert to show up to the hearing, that is coming out of the client's pocket. You cannot recover costs or disbursements even if you win at the license appeal tribunal. You will only be awarded the wage replacement, perhaps interest, maybe a special award if the insurer was not acting in accordance with the statutory accident benefit schedule. I refrain from using the term bad faith because since the regime changed even further, you no longer have the right to actually sue an insurance company. You can only appeal. So you're not going to the Superior Court. You're not going to the Ontario Court of Justice. They also took away the right to sue for bad faith. So there's quite a few issues in this cost benefit analysis for our clients to really think about and recognize before going through with the hearing, because there is so much risk involved. Because even if you win, suppose you win, and you're awarded, however much money, there's going to be a clawback because of the money you have to spend that you cannot recover from the other party that is now lost, which before 2016, you were able to sue an insurer, you were able to recover your legal costs, you were able to recover your disbursements.
See, that reminds me of your case, Richard Castrillo, where you were successful, like in WSIB WSIAT matters, injured workers. The, Theoretically, and I could be wrong, Richard, is if you use an expert, the board may, just like you were saying, Mr. Sharma may pay for the expert report, but not likely. But where the bigger thing in general is what we call is the court costs. That's where Richard was successful in a class action, but he proved the board itself was acting. Uh, you can talk about that, Richard, is acting not honestly or in bad faith. But your situation becomes really interesting because now it's like a separation of the two. Is the board with workers' comp is the, so to speak, insurance body and deciding body until you get to the WSIAT. So it's like,
Let me ask Mr. Sharma a question, which is, do the insurance companies generally just follow the family doctor up to the 102-week mark?
Sorry, I didn't catch that last term.
Yeah.
You follow.
Does the insurance companies, in terms of paying the weekly $400, will they follow the advice of the family doctor up to the 102-week mark?
No, because before the 102-week mark, it's almost, I'd say 95% of the time, the insurance company will send you to their own medical doctors or examiners, and they're going to heed to the opinion of their own experts.
So they have experts that they retain, say, who people work at Sunnybrook, doctors who work at Sunnybrook or at Toronto Western, etc.
Correct.
Right. And one of the things I wanted to ask you is in the last few weeks, I've noticed that the WSIB is now using physiotherapists to render opinions. I wonder if you've seen that yet.
That's been very common for quite some time in the motor vehicle accident world. They use physiotherapists, kinesiologists, occupational therapists, non-MDs very regularly render an opinion.
And they're using those to overrule the opinions of the family doctors?
I would say they're overrule might be. I would say the insurance companies are always going to heed to the opinion of their own experts, whether it's an MD or not, and they will go over and above any opinion of our clients' own OHIP funded doctors with no problem. They have no issue with ignoring our medicals.
what about when, like with the WSIB, what I've noticed recently is they'll say in the WSIAT Act, it says that you only have to cooperate in an assessment, an examination by the board. But what I've noticed they've been doing is telling or misleading the injured worker that they have to go to their treatment people. Have you noticed that where the insurance companies are saying you have to go to our physiotherapists or our doctors to receive treatment?
That's a good question. It's very common that the accident benefits insurer or your own insurance company will tell you, well, hey, we have these preferred physiotherapy clinics or chiropractic clinics, and there's one right around the corner from your house, and you should attend here. So that's very common. There have been cases where they say you must go here, which is not allowed. The insured individual is allowed to go to any clinic of their choosing, so long as that clinic um, bills through what's called an HCI system, which is a totally different topic related to billing, but you have to use the insurance company's billing system in order to attend a particular facility.
Yeah, I noticed the same with WSIB and workers' comp in general across Canada. Um, the other question I wanted to ask quickly is in doing the return to work, like if you have some workers where they're in the view of the insurance company that they're capable of returning to some form of work, and it becomes the dispute with the doctor or the insurance company's doctor. What I've noticed in the WSIB side is when they're saying, well, we think you can return to work or whatever, they're completely ignoring the human rights code, which even in the case of private insurance applies to insurance companies. Do you find that they're ignoring the individual when they're saying, like, look, I can't do that, I have a disability, whatever? Like they're ignoring the human rights code?
I would say the human rights code very rarely, if ever, comes into play when it comes to the accident benefits regime. It's
Mhm.
very narrow what legislation we can use and put before the license appeal tribunal. I would say that as far as ignoring one's, inability to work or, what their impairments may be, it's on every single one of our cases, and the insurers and their counsel often revert to the argument, well, it's your claim to make. Your client only has subjective complaints. This is most common in claims where individuals have what we call invisible injuries. There might not be any broken bones, but they might be in severe physical pain. They might be in a chronic
Chronic
pain
pain.
state. Yeah.
Yeah, there's a good decision that was issued by the Supreme Court on that topic, Nova Scotia v. Martin. And the Supreme Court basically said, what was it again? Something to the effect that because chronic pain can't be objectively measured, that chronic pain sufferers are often treated as malingerers by employers, by doctors even, and the compensation staff. So it's a very interesting decision that I read in that relation that feeling that they can take that position and say, well, you must be faking when there's no foundation or basis for this accusation of faking.
How often do medical doctors show up at these hearings?
Um, well, they will show up as long as you call them and they're available. How often these matters actually go through to a hearing, I think is a bit of a different story because I'm not sure if through WSIB you can come to a full and final settlement. Are you able to?
No, they don't have a settlement. They have is a decision, solely decision making, and then a fairly lengthy appeals process.
Okay. So, with the license appeal tribunal and with accident benefits, you're able to come to a settlement where you resolve the entire matter for all past and future claims. And because of that mechanism, I'd say, 95% of claims will resolve before you actually get to the hearing.
And when you say resolve, is this like they issue you a final payout, or they say we'll cover you for another 50 weeks of employment loss?
So it can be a combination of a resolution. If it's a full and final, it'll be, indefinitely, past, present, and future. You can be creative and you can say, hey, well, if you agree to simply pay this individual's income replacement benefits again, then we don't have to go through this hearing. Here's the evidence, and you just simply come to an agreement. You withdraw your application. They continue to be paid income benefits. However, in that scenario, the insurer is still entitled to request another insurance examination. And usually they can request an insurance examination related to income benefits once a year.
Because what I was thinking was, doctors almost never come to hearings in the workers' comp system.
Oh,
And doctors, let's say orthopedic doctors, they want anywhere from $1,500 to $4,000 to do a report. I'm told it's even higher in motor vehicle cases. And if you're going to drag them to the hearing, you're looking at least $6,000 all in. And meanwhile, you're fighting over $400 a week. So it would seem the ability to haul doctors in on the side of the claimants would be few and far between.
absolutely. You nailed it. I mean, the cost associated with going to a hearing for $400 a week, the your client and the council really have to take a long and hard look at this cost benefit analysis because it is so expensive. And like we discussed earlier, you cannot recover these costs before the license appeal tribunal.
Does the insurance companies use private investigators to watch claimants to see whether they're doing something productive when claiming disability?
Absolutely. They love their private investigators and their social media sweeps as they call it. And oh, we saw you taking out your garbage can. And it's like, yes, I can take out a garbage can, but ask me to do it, 30 times in a row like I would be doing something repetitively at work, and let's see what happens then. So for sure, they love their they love their video surveillance and their social media searches.
And I assume part of the problem is with the provincial government in that, in an effort to keep car insurance rates down, they try and suppress the claims and pay little, except where there's clear liability on the part of the person who caused the accident.
Yeah, for sure. I mean, insurance companies want to pay you as little money as possible and, make as much money as possible. At the end of the day, it's, I think in Ontario, at least, it's probably the most successful subscription business. It's required by law. Everybody has to have automobile insurance. If you don't have automobile insurance, you can, get into some trouble. Insurance companies they're going to do whatever it takes to get their discount where they can and not pay in its entirety when they can. And even if you are severely injured and they see your personal life circumstances, if you have a mortgage, do you have children? Um, they're gonna take advantage of that if they know you have a mortgage or you have a home, um, and they feel that they can win at trial. And this is not at the license appeal side, but let's say the pain and suffering side, and you lose, you're liable for their costs. But I don't want to switch gears too much, and we should just focus on the appeals aspect. But we know insurance companies love to spend money to develop the case against you, but not pay you out when you're deserving of it.
There's a book on that subject from the US, which brought into the media over that shooting was, what was it? Delay, I always screwed up. Delay, deny, defend. A very interesting book on the attitudes of insurance companies of the last, I would say, 2 to 3 decades, since the 1990s. That's what, almost 3 decades. God, I'm getting old. The other thing I noticed too quickly was, and you'll find this interesting, Richard, is there's actually a clause in the Act, the Statutory Benefits Act, Section 10. There's no violation to the Human Rights Code with its distinction of age. And they actually do discriminate on people, just like you, Richard, over the age of 65. So in
Don't
other
make
words,
fun
you'll
of
get,
me, please.
what's that?
Don't make fun of me.
You'll get you'll get less benefits than I would. Well, for now, because I'm not far behind you, right? When to me, I don't see a person by age as any distinct different. But that's what I've noticed in the laws of the last few years is they're really discriminating on age. What do you think of that, Mr. Sharma?
Um, so I would say there's a bit of a distinction there. So if you know if you're entitled to income replacement benefits after the 2 year mark of your accident, that means that the insurance company agrees that you meet the test for any occupation, meaning that you cannot participate in any occupation based upon your age, education, and experience. And to be fair, what the legislation states is that if you are receiving the wage replacement beyond the age of 65, you'll be paid wage replacement from 65 to death on a reduced basis. Okay, so there's a ramp down calculation. Um, I don't want to complain too much about that because, simply put, there's an argument. Well, how long would you have been working for? Is it 65? Is it 70? Is it 75? Is it really to death? It's quite rare. But you are correct that there is some discrimination based upon age as far as the accident benefit schedule is concerned. I would say the discrimination also occurs in a different manner. What the accident benefit schedule says is that you qualify for income replacement benefits if you were employed at the time of the accident, or not employed, however, working in the 26 of 52 weeks prior to the accident. So that's for individuals who are employed by another corporation or individual.
Mm.
But let's say that you were self-employed. Let's say that your accident occurred today on August 28th, 2025. And you were working for another company from January 1st, 2025 to, July 31st, 2025. And then on August 1st, 2025, you said, you know what, I'm going to start my own company. So now you are self-employed at the time of the accident. What the case law is saying and what the legislation states, which I believe is, completely incorrect, but what the legislation now states is that in order to qualify for income benefits as a self-employed person, you must have completed 1 fiscal year as a self-employed individual. And if you have not completed a fiscal year as a self-employed individual prior to the accident, well, guess what? You're not getting any income replacement benefits. Your quantum is 0 because they cannot calculate it, because the legislation states you must have completed a fiscal year. So they will not use a combination of being employed and self-employed, which is really unfortunate because there's, this happens, and insurance companies aren't telling individuals when they purchase their insurance, well, hey, just so you know, you're paying for income replacement benefits. However, if you weren't self-employed, if you don't meet this test, we're going to continue to charge you for it, but we will not pay you any wage replacement.
Are there sort of political lobbying groups on behalf of the claimants that are doing some lobbying currently?
Yeah, I mean, the Ontario Trial Lawyers Association does lobby all their, whatever political parties within your jurisdiction to have a more liberal reading, I would say, or maybe make some amendments to the SABs or the statutory accident benefit schedule. Frankly, it hasn't gone very far. I can tell you that in 1990, income replacement benefits was capped at $600 per week. That was reduced in 1996 to $400 per week as a maximum that the insurance company has to pay you, your own.
Because you'd be homeless if you had to
I was
live.
just going to say that won't even cover the average rent.
It's $20,800 a year. And I can tell you since 1996 until today, was that about 30 years, there has not been a single increase in wage replacement from that $400 a week amount.
The
So,
other question,
yeah,
sorry, Richard.
Yeah, so the injured workers have something called the Ontario Network of Injured Workers Groups, who has an Injured Workers Day on June the 1st. They'll be marching on September 1st, I think, which is the Labor Day. So might want to give a poke out if someone sees this before Labor Day to see where the march is going to be by injured workers. But the injured workers do have some lobbying they do on their own. I assume motor vehicle victims don't.
It's like I said, it's mostly the lawyers. I'm not sure if there's a specific lobby related to individuals injured in a motor vehicle accident, but the Ontario Trial Lawyers Association does do its part.
Okay. Paul, you
Uh,
want to close it out?
oh, yeah, sorry, one quick question. You were talking about income replacement benefits, and you said, well, if I'm working, I'll get literally pennies on the dollar. And then if I'm self-employed, I may not get anything. What about in situations where, say, I'm at university or college and I'm just getting ready to graduate to become a lawyer and make a little bit of money, and I'm involved in a car accident, which then I'm done. You know what I'm saying? How does the system and the insurance company deal with that?
That's a good question. So, if you're at fault for the accident, you're only going to have access to the statutory accident benefit schedule, or your own insurance company will have to compensate you up to $400 a week if you meet that test I mentioned. Either you were employed at the time of the accident, or you were not employed, but did have income coming in the 26 of 52 weeks prior. If you're self-employed, you must have completed a fiscal year. If you're a student who is just studying and were, I guess fortunate enough to not have to have a job, then the insurance company only has to pay you $185 a week for a maximum of 100 weeks. Okay, so if you're at fault, that's it. Okay, it's $185 a week for 100 weeks if you meet a test called the non-earner benefits test, meaning you have a complete inability to live your normal life. And what your normal life is, I mean, perhaps we can talk about that on another podcast. But if you were not at fault in this situation and you were not working and you're entitled to non-earner benefits, then you would have to sue the at-fault party and claim all of your future income loss from that at-fault insurer in the Superior Court of Justice if it goes that far.
How long do you wait for a LAT hearing these days?
So the way it works is before the actual hearing, you'll have a case conference. We usually get a case conference date, which is done over the phone on a telephone call, about I'd say 3 to 4 months after filing the appeal. And then from the date of the case conference, I'd say that you're waiting anywhere between 4 to 6 months for the actual hearing date.
So very similar to WSIB situation. Well, thank you very much for coming on our podcast and making us feel not so bad about workers' comp. At least
And
the
thank you for
maximum
having me.
insurable earnings are about 110,000 at the moment. And thank everyone for attending. See you all later.
Thank you so much. Bye bye, everyone.